Karen hired contractors to bulldoze the cabin on my private island, insisting I owed $12,000 in HOA dues. But when a professional survey confirmed the island was my separate property completely outside HOA authority, she realized she had just committed felony criminal mischief on land she had zero jurisdiction over. My name is Tucker, and I am a commercial real estate developer based in Charleston, South Carolina. I have spent 22 years acquiring, developing, and managing properties throughout the Southeast. I understand property law, deed restrictions, easements, and jurisdictional boundaries better than most attorneys ever will. What Karen did not realize when she ordered the destruction of my island retreat was that she had trespassed on land that was never part of the HOA, authorized the demolition of a structure she had no control over, and committed crimes that would ultimately cost her everything. I own property in two distinct locations. My primary residence is in Tidewater Estates, a coastal subdivision built in 2008, about 15 miles north of Charleston. The community sits along the Intracoastal Waterway and has an active HOA that manages roads, a boat launch, and common areas. But I also own something else, a 3-acre private island located roughly 1 mile offshore from Tidewater Estates. The island is called Tucker's Point, named by the previous owner who sold it to me 8 years ago. The island is entirely separate from Tidewater Estates. It has its own deed, its own tax parcel number, and was never included in the original subdivision development. I purchased it independently in a completely separate transaction years after buying my home in Tidewater Estates. The island has a small dock, a rustic cabin I built for weekend getaways, and untouched natural vegetation. I use it for fishing, relaxation, and occasionally hosting small gatherings with friends. Access is by boat only, about a 10-minute ride from the Tidewater Estates boat launch. For 8 years, I owned both properties without a single issue. The HOA knew I owned the island. Several board members had visited it over the years. There was never any dispute that the island was my private property, entirely separate from the subdivision. Then Karen moved into Tidewater Estates 9 months ago. She had perfectly styled blonde hair and immediately ran for the HOA board, winning easily. Within 2 months, she became president. Her agenda centered on aggressive dues enforcement and expanding what she believed was HOA authority. 3 months ago, I received a letter from Karen claiming I owed $12,000 in special assessment fees for the island property. The letter stated that all properties associated with Tidewater Estates residents were subject to HOA assessment and that my island fell under that category. I called her immediately. Karen, my island is not part of the HOA. It is a separate property with its own deed and tax parcel. You have no jurisdiction over it. You access the island using our boat launch, which makes it associated with our community. Using the boat launch does not give the HOA authority over my island. It is private property outside your jurisdiction. The board has determined that all properties used by residents fall under our authority. You owe $12,000. I am not paying HOA fees for property that is not part of the HOA. This is absurd. Then we will take enforcement action, she said before hanging up. I ignored the demand, assuming she would realize her error once she consulted the HOA attorney. I was wrong. 2 weeks later, I received a certified letter claiming the HOA had placed a claim against my island for unpaid dues and would pursue all enforcement actions if payment was not received within 30 days. I contacted my attorney, a real estate lawyer named Marcus who had handled my island purchase years earlier. I showed him the letters. Marcus laughed. Tucker, this is legal nonsense. The island is not part of the HOA. They have no authority over it whatsoever. Access from the boat launch is irrelevant. That's a common area amenity. It does not extend HOA jurisdiction to wherever you travel by boat. What should I do? I'll send them a letter explaining they have no legal standing. That should end it. Marcus sent a detailed response, including copies of the island deed, the subdivision plat map proving the island was excluded, and legal analysis explaining that HOA authority is limited to properties within recorded subdivision boundaries. Karen responded by sending another letter doubling the claimed assessment to $24,000 for noncompliance and legal fees. I was traveling for business over the next 2 weeks and didn't think much more about it. The claims were baseless, and I assumed reality would eventually force Karen to back down. I returned home on a Thursday afternoon and decided to take my boat out to the island for the weekend. I loaded supplies, made the 10-minute crossing, and approached my dock. The cabin was gone. Where my retreat had stood for 8 years, there was now only a bare foundation and piles of debris. The structure had been completely destroyed. I tied up and walked the site in shock. The cabin had been bulldozed recently. Fresh equipment tracks were visible in the soil, and the debris was clearly new. A notice was posted on a stake near the foundation. Structure removed by order of Tidewater Estates HOA for non-payment of dues and unauthorized construction on common property. I took photos of everything: the debris, the foundation, the notice, the tracks. Then I called Marcus immediately. Marcus, they bulldozed my cabin. The HOA hired contractors and destroyed my property. What? When? Within the last few days. I just arrived. It's gone. That is criminal mischief and trespassing. Call the Charleston County Sheriff right now and file a report. Then call me back. I contacted the sheriff's office and reported the destruction. A deputy arrived by boat within 40 minutes. Deputy Johnson walked the site with me, photographed everything, and took my statement. Mr. Wallace, do you have documentation proving ownership of this island? Yes. Full deed, survey, and tax records. The island has its own tax parcel completely separate from the subdivision, and the HOA claims they had authority to demolish your structure? Correct. They've been demanding HOA dues for the island, which makes no legal sense because it isn't part of the HOA. Deputy Johnson reviewed the notice left behind. Contractors, Deputy Johnson continued. This notice says the structure was removed by HOA order. Do you know which company performed the work? No, I replied, but there should be records. Someone hired contractors and brought heavy equipment out here by barge. He nodded. I'll investigate. This appears to be criminal mischief at a minimum, possibly felony level depending on the value of the destroyed property. Over the next week, the investigation progressed rapidly. Deputy Johnson identified the demolition company as Coastal Contractors, a legitimate firm that had been hired by the HOA to remove what they were told was an unauthorized structure on HOA common property. The contractor provided documentation showing they were hired directly by Karen, acting in her role as HOA president. She had told them the island belonged to the HOA and that the cabin was constructed without approval. The company admitted they had not independently verified property ownership and had relied entirely on Karen's representation that she possessed authority as HOA president. Deputy Johnson obtained my property records and confirmed the island was privately owned with no legal connection to the HOA. He also secured professional estimates to rebuild the cabin, totaling approximately $45,000. Because the value exceeded $2,500, the destruction qualified as felony criminal mischief under South Carolina law. Karen was arrested 2 weeks later. She was charged with felony criminal mischief, felony trespassing, and making false statements to contractors. She attempted to argue that she genuinely believed the island was HOA property, but the evidence showed she had been informed multiple times that it was private land, including through Marcus's detailed legal letter. Her own emails to other board members revealed she knew there was a dispute over the island's status, yet she proceeded with the demolition anyway, writing, "We need to take decisive action, and he'll back down once he sees we're serious." The Charleston County Solicitor's Office prosecuted the case aggressively. The evidence was overwhelming. Official property records establishing ownership, proof that Karen had been informed the island was private, her authorization of demolition despite that knowledge, and the $45,000 value of the destroyed cabin. Karen's attorney attempted to negotiate a plea agreement, but the solicitor's office refused to be lenient. The case went to trial 6 months later. I testified about the island's ownership history, the letters demanding impossible HOA dues, Karen's refusal to accept that the property was outside HOA authority, and the shock of discovering my cabin demolished. Marcus testified as an expert witness on property law, HOA jurisdiction, and the legal impossibility of Karen's claims. The demolition contractor testified that Karen personally hired them and assured them the island was HOA-owned and the demolition authorized. Deputy Johnson testified regarding the investigation and the clear evidence of intentional destruction. The jury deliberated for 4 hours and returned guilty verdicts on all charges. The judge sentenced Karen to 3 years in state prison, with 18 months to be served and the remainder suspended to supervised probation. She was also ordered to pay full restitution of $45,000 for rebuilding the cabin, plus $15,000 for legal fees and investigative costs. The HOA itself was not criminally charged, but the board immediately removed Karen and issued a formal apology. They acknowledged the island was my private property, rescinded all prior demand for dues, and offered to contribute toward reconstruction, even though they were not legally obligated to do so. The new board president, a reasonable man named David, visited me personally. "Mr. Wallace, on behalf of the community, I apologize for what happened. Karen acted without board authorization and misrepresented the facts. We want to make this right." The board contributed $10,000 toward rebuilding as a goodwill gesture. Although the HOA's insurance would not cover Karen's criminal conduct, I hired contractors and rebuilt the cabin over the next 3 months. The new structure is slightly larger and far better built, with improved foundation work and hurricane-rated construction. Karen served 14 months of her sentence and was released on supervised probation. She was required to make monthly restitution payments, though given her financial condition, full repayment will take years. She moved out of Tidewater states immediately after her release and relocated to another state. The island remains my private retreat. I've hosted several board members at the rebuilt cabin, and there has never again been any confusion about property boundaries or HOA authority. I installed additional signage, clearly marking the island as private property, and posted copies of the deed and survey at the dock. If ownership is ever questioned again, the documentation is impossible to miss. The case became well known in Charleston real estate and HOA management circles as a cautionary example of catastrophic overreach and the importance of verifying property boundaries before taking enforcement action. Several HOA management companies now use my case in training materials to emphasize jurisdictional limits and the necessity of consulting attorneys before aggressive enforcement. I still live in Tidewater Estates and maintain a good relationship with the community. Most residents were appalled by Karen's actions and supported me throughout the criminal proceedings. After the trial, my attorney Marcus framed a copy of the island deed and gave it to me as a gift. It hangs in my office beside a photo of the rebuilt cabin. Every time I take my boat out to the island, I think about the moment Karen realized she had bulldozed a structure on private property completely outside her authority. The shock, the denial, and the eventual understanding that her overreach had led to felony charges and prison time. If you've ever had an HOA claim authority over property it doesn't control, or had property destroyed under false authority, share your story in the comments. Send this to anyone dealing with HOA overreach and remind them that jurisdiction has clear legal boundaries that cannot be expanded by aggressive demands. And subscribe for more stories about people who learn that property ownership is established by deeds and surveys, not by claims from self-appointed authorities. Sometimes, the property you choose to bulldoze turns out to be completely outside your control, and the consequences are criminal, not civil.